war never changes. An infamous phrase from the video game Fallout, a game that depicts a nuclear wasteland as consequence of a great war between different factions. This phrase, despite being a signature for the game series, has a lot of meaning within what has been about wars in our world history. No matter what kind of armed conflict happens, the ways of war will never change. Is it though? This phrase has left the people thinking about war itself. Does it really stay the same all the times we go to war? Or does it change? This is where humanitarian law comes down and responds our questions by teaching us that war, actually, needs to change. But what is humanitarian law? International humanitarian law, or also known as law of war or law of armed conflict, is the set of rules which seek to limit the effects of armed conflict, for humanitarian reasons. This isn't the same as human right law and must not be confused with humanitarian law, due to the fact that human rights law is a separated set of rules contained in a different treaty and which only applies in peaceful times within states, while humanitarian law doesn't. This is part of international law, which applies to armed conflicts, but it does not regulate whether a state may use force over a conflict. So where did humanitarian law originate? This law is rooted in the rules of ancient civilizations and religions. Warfare has always been subject to certain principles and customs, but universal codification of international humanitarian law began in the 19th century, in the 4 Geneva Conventions of 1949, where nearly every state in the world agreed to be bound by them. Since then, states have agreed to a series of practical rules, based on the bitter experience of modern warfare. These rules strike a careful balance between humanitarian concerns and the military requirements of states. As the international community has grown, an increasing number of states have contributed to the development of those rules to form a universal state of law. The conventions have been developed and supplemented by 2 further agreements, like the additional protocols of 1977 relating to the protection of victims of armed conflicts. Other agreements prohibit the use of certain weapons and military tactics and protect certain categories of people, like the 1972 Biological Weapons Convention, the 1980 Conventional Weapons Convention and its 5 protocols, and the 1993 Chemical Weapons Convention. These provisions have been now accepted within the international community as customary law, that is, as general rules by which all states are bound. What does humanitarian law cover? This law covers only 2 areas. 1, the protection of those who aren't taking part in fighting, and 2, the restrictions on the means and the methods of warfare. Regarding the protection of people, this law protects those who doesn't take part in the fighting, like civilians and medical and religious military personnel. It also protects those who have ceased to take part, like the wounded, the sick combatants, and the prisoners of war. These categories of person are entitled to the respect for their lives and for their physical and mental integrity, which they also enjoy legal guarantees. To be more specifically, it is forbidden to kill or wound an enemy who surrenders or is unable to fight. The wounded must be collected and cared by the party in whose power they are, and medical personnel, supplies, hospitals and ambulances must all be protected. There are also detailed rules that governs the conditions of detention of prisoners of war and the way in which civilians are to be treated when under the authority of an enemy power, which includes the provision of food, shelter and medical care, and the right to exchange messages with their families. To ensure these practices, the law sets out several recognizable symbols which can be used to identify protected people, places and objects. Examples of these symbols are the Red Cross and the Red Crescent. Regarding with the restrictions of warfare, this law has prohibited all means and methods of warfare which fails to discriminate between those taking part in the fighting and those who aren't, cause superfluous injury or unnecessary suffering, and cause severe or long-term damage to the environment. Also, humanitarian law has banned the use of many weapons like exploding bullets, biological and chemical weapons, blinding laser weapons and anti-personnel mines. But when does international humanitarian law apply? This law applies only to armed conflicts, it doesn't cover internal tensions or disturbances within a state. This law applies only once a conflict has begun and then equally to all sides regardless of who started the fighting. But to apply this set of rules, humanitarian law must distinguish between international and non-international armed conflicts to begin applying. In the sight of the international community, an international armed conflict are those in which at least two states are involved, which they are subject to a wide range of rules, including those set out in the 4 Geneva Conventions and the additional protocols, while non-international armed conflicts are those restricted to the territory of a single state, involving either regular armed forces fighting groups of armed dissidents, or armed groups fighting each other, which they are subject to a more limited range of rules. Despite having a firm and legal structure in the international community, is this law really fulfilled? Yes, and no. Sadly, there are various cases of violation of humanitarian law, but also, important cases where this law has made a difference in protecting civilians, prisoners, and in restricting the use of barbaric weapons. Given that this law applies during times of extreme violence, implementing it will always be a matter of great difficulty. That said, what should be done to accomplish it? There has to take measures to ensure the respect for this law, with the obligation of states to teach its rules to their armed forces and the general public, which they must prevent these violations or, if these cases occur, punish them. The states also must enact laws to punish the most serious violations of the Geneva Conventions and its additional protocols, which are regarded as war crimes. Also, they must protect the Red Cross and Red Crescent emblems to ensure its appliance. Measures have been taken at an international level. Tribunals have been created to punish acts committed recently, like the cases of Yugoslavia and Rwanda, and an international criminal court has been created with the responsibility of repressing war crimes. In the end, war needs to change, and to ensure the effectiveness of humanitarian law we need to disclose this information to others and demand the compliance to our state of this law, and hopefully, one day, this law wouldn't be necessary at all.